Planning for the unexpected may not be fun. Nobody wants to talk about death, but it is absolutely crucial to make sure that there are plans in place so your real estate can pass to your loved ones and that all of the estate process can be handled with ease. In today's video, we're going to talk about some different ways to ensure that your real estate affairs are in order. That way, when you pass away, your loved ones are taken care of during tough times, and the probate that they have to go through is simple and straightforward. Hey everyone, welcome back to Living in Spokane, Washington. I'm your local real estate broker. My name is Hunter McKay. Today's topic is a sensitive but important one: preparing to handle probate efficiently. It doesn't matter if you're looking to protect your family's future or ensure a smooth distribution of your assets after you pass on. This is an important video for you to watch. If you have any questions that are not handled by this video or just feel like you would like a personal dive into your specific situation, every probate can be unique, and I have a lot of experience working with families going through probate and preparing for their estate planning meetings. So please reach out and I would be more than happy to meet with you and the family to make sure that everything is handled accordingly. Before we dive into the specifics, let's talk about what is estate planning. Plain and simple, when you pass on, you have ownership of a whole bunch of stuff. That's physical property, cars, real estate, stocks, cash. Anything that you have acquired over your lifetime is part of your estate. And there are laws that dictate what happens to it if you haven't told them what you want to do. The easiest and simple way to go about this is have a living will and trust that explains what is going to happen. And so the living will can dictate what happens to your assets after you die. And in certain circumstances, a trust can protect your assets after you die. That way they're protected in a certain way to be used by your family or heirs. It is really crucial to make sure that a strong will is in place, preferably one that is written and maintained by an attorney, especially the attorney who is going to execute and handle the probate when you pass away. If a will is not in place, it can leave room for a lot of legal battles down the road for your heirs. Please make sure that you take the very brief time to meet with an attorney. A will can cost as little as $500 or $1,000 if you're meeting with a private attorney, and you can get one created on LegalZoom or other such websites for much, much cheaper. I personally, for something as serious as a will, would really recommend meeting with a private attorney. That way they can coach you through the things that you need to be thinking about for your specific situation. As a probate advisor and a real estate broker who handles probate transactions, I have seen countless situations where people thought something was one way, and in reality, it was going to go a completely different way. Because ultimately, no one who handles the probate on the judicial side or the real estate side can legally deal with what you were told or what you remember or what you think was going to happen in the past. It only matters what is documented, because when the person who passes away is gone, we can't ask them what they intended. We have to rely on the written word that's left over, which is why a written will is so important. In Washington specifically, this is a common law state. And so what that means is that for people who are married, they both own the property together. And if a married couple, one of them should pass on, the law in Washington stipulates that the property automatically passes to the married partner. That's the only real situation where I think not having a will is acceptable. However, what's the guarantee that one of you passes on and the other survives and is in a mental state well enough after that happens to now do estate planning? So it's why I always advise people, just do it in advance. I'm 30. I have a written will that stipulates where everything will go. I don't anticipate dying anytime soon. Hopefully I live a very long life. But if I die, there's a will that dictates where everything is going to go. Right now, the assumption is that if I died tomorrow, my mother is still alive and I have to have someone take care of her. So all of the assets go to her. But what if she should predate me in death? There's a stipulation in my will for that. And so I've thought about all of the different avenues that might happen, and I've lined out the people that are important to me in my life to make sure that they get control of the assets in accordance with the timeline that I think is most likely for them to be needing it without me present to make the decisions. I don't want them all fighting later over what I might have determined, and so it's very easy for me to write it all down now and leave it with my attorney who is in charge of dispensing all of the assets should I pass away. One of the biggest mistakes that I see people make in estate planning is making assumptions. Well, I'm sure it'll be okay. Well, little Timmy never said that he wanted that. Well, Uncle Tommy said that I could have the Corvette in the garage. Well, Grandpa Tom always said that I was going to get that grandfather clock. People do weird things in death. When people are grieving and people are sad, people get angry. And all of a sudden, old family wounds open up and people go for their revenge and recompense, usually in the form of items that they feel they are deserved and owed. It is not the time to fight about items when your loved ones have passed on. I have watched families get ripped apart over what I thought to be the most ridiculous reasons, simply because everyone felt really invalidated by being ignored, and they were in the throes of grief, and so they fought back, and they fought back dirty. And I don't think that any of those individual people would have behaved that way if not in the throes of grief, anger, and sadness. And so spare your loved ones that fight when you are gone, because they will miss you. And especially if you are the one who has been the balance portion of your family, the one who has held the control and generally driven the dynamics, missing and losing you will be dramatically different for your family's dynamics afterward. Write down the intentions of what you wanted and tell them what you intended, and make sure that it is ironclad and a third party is there to direct everyone what is in the will and what was authorized. That way, there's no question what your intentions were, and the fights can be left alone. Next, let's talk about some key documents that it can be important to have in place early on. That way you know that you're well protected. One of the first, most basic documents is really not the will. It's the power of attorney. What happens if you get incapacitated? You need to have a medical and financial power of attorney assigned to someone that you love and trust. That way they can make decisions for you. The medical and financial power of attorneys do not have to be the same person, and sometimes in certain families they aren't, because you might want a more compassionate or less compassionate person making your medical choices depending on how you feel about life. You might want someone more financially prudent handling the financial affairs, especially before you pass on. However, it's really important to make sure that those power of attorney documents are in place, and please notify the person that you are making them your power of attorney and explain to them the details of what this means. Don't just say, hey, can you do this thing for me, and get their signature, because it's a big deal and they should know what they're signing up for, and they should know in advance what the commitment is that you're expecting from them. Beyond the power of attorney, you need to have a will and or a trust. Not everyone needs a trust. It's going to be up to your specific family situation and dynamics to determine if a trust is necessary. Most notably, trusts are used for families who obtain a lot of assets over time and want to maybe not sell them. Usually, when someone passes on, the family immediately starts selling off the assets and generating liquid capital, because the heirs most usually want money more than they want stuff, especially if their life is not set up to receive buildings or properties or rentals. However, I have had clients that say, Hunter, I do not want my heirs to be able to sell the property. I know the properties will be making income, and I know that my great-grandchildren years from now might be spoiled. I want to be able to protect them and let them be spoiled. And I said, okay, well, the best way to do that is lock everything up in a trust that limits the beneficiary's ability to sell the assets down the road. Maybe they have to keep them in the trust management for a decade or 2 decades. Now, this can be dangerous, because what if you don't have the money to maintain the properties? And so it's really important to meet with an appropriate estate planner, a real estate broker, and an attorney to make sure that you have considered all of the different avenues that you need to in order to make sure that your family is well protected. But a will is most important. Tell everyone what your intentions are with your assets. What do you want us to do with your stuff when you are gone? Because if you don't, we will decide for you, and people will fight about it, and it will be messy. The last thing that we need to talk about is beneficiary designations. You might identify multiple different beneficiaries for different types of assets, and that's perfectly okay. But you need to let us know in advance in that will document who are the beneficiaries of your estate. who is getting what positions and what portions are going to them. And the more stuff you have, the more detailed you should be. That way there's no question later. Let's talk about the probate process. Probate is what happens after death. All of the assets go into a probate process. Primarily today we're going to talk about the real estate assets because I'm a realtor. The biggest thing to understand is that if a will has been executed correctly, there's going to be an executor of the estate. The executor of the estate is not necessarily a beneficiary. They could be a third party, a trusted family member, or a friend who is just there to make sure that the will and the original requirements from the deceased party are honored. And so that executor is going to look through the will documents and work with a probate attorney to complete and file the probate. They have to open the probate with the state of Washington and declare all of the assets. And then over a 90-day period, everyone has an ability to assign debt to the estate. The reason that this is done is that we're no longer sure who the dead person owes money to. And so we have to make sure that all of those debts are paid before we start dispensing assets, because the deceased assets are only due to the inheritance cycle if everything is paid up in advance. And so if there's a huge balance of medical bills due to the state of Washington, everything could be sold and forced to be paid to pay off that debt. And so there are loads of situations where the estate may not actually be large enough to handle all of the encumbered debt. In that situation, there's not going to be any inheritance for any of the heirs. And so it's important to work with the appropriate parties to make sure that that debt is handled appropriately. For the sake of this conversation, let's assume that there is money left over in the estate, that there is a property that's maybe it's paid off and it needs to be sold. Maybe it's not paid off, but it has equity in it. The executor is going to have to work very quickly to make sure that the will is honored. If the property is said to be sold in the estate property documents, it's easy. We just list it for sale and we work with a real estate broker to get it sold after that 90 days in probate is complete. But once the probate is complete, the executor is given a document that essentially says you, on behalf of this estate, has the legal authority to dispense with all of the assets in the estate. At that point, they can begin signing them over to the different heirs or selling them and giving the money in the equity splits that's necessary to honor the will that is essentially a contract between all of the heirs. In essence, the probate process is the legal distribution of your assets. When you pass away, the executor is notified that they have a job to do. They file the probate, and as soon as the probate is complete, they're given a document that says, hey, you're now in charge. Go forward and do what the will tells you to do. Hopefully, no one fights. This is the opportunity for heirs to come and lay claim against the estate. Hopefully, if you've done your job right, everyone says, okay, great, we approve, and we appreciate that the will is being executed the way that everyone intended. But this is why communication ahead of time, when you are still alive, is really important. I know that talking about money is hard and challenging, and a lot of families don't want to do it. So just do it once a year and make sure that the will and trust documents are updated and that everyone understands what the commitments are, because tragedy can strike at any time. And when tragedy strikes, you don't want to not have these things finished. You want to be able to focus on what's really affecting your family and have all of these things already finished protecting you in the background. I know that we've covered a lot of heavy stuff, and at certain points I felt like I might have been rambling, but please just know that the estate process, while complicated, is so necessary to protecting your family's long-term future, and in many cases reducing the inheritance and capital gains taxes that your heirs will pay. And so if you have any questions or you're concerned, or overall this video just made you feel icky and you're like, oh God, I'm overwhelmed, now's the time to reach out to me and say, hey Hunter, I need a meeting with you. I have been doing this for many years and I can make the process as fun as possible given the topics that we're discussing. Don't forget to like, subscribe, and comment for any more real estate tips, especially in handling the probate process. My team and I are here to help support in any way that we can.